Earth and frivolity.
Good morning, folks. My name is Hitzemann, County Court Judge here in Hernando County. You folks are here for your first appearance. The purpose of the first appearance hearing is so that you may be informed of the charges against you. I will determine if there's probable cause for those charges. Probable cause simply means that it's more likely than not that a crime has occurred, more likely than not that you're the person who has committed the crime. Of course, as you stand before me this morning, I presume that you're innocent of all charges. That presumption of innocence will stay with you through every stage of the proceedings, unless and until the State Attorney's Office is able to prove the allegations against you beyond and to the exclusion of a reasonable doubt. We'll set your conditions of pretrial release this morning, that is your bail or bond. Most of you have had a bond set already pursuant to the bond schedule here in the 5th Judicial Circuit, or the warrant which led to your arrest. I'll determine if that bond should be raised or lowered or left the same, or whether there'll be additional conditions of pretrial release placed upon you. We'll let you know when your next court date will be, and if you'd like to have the services of the public defender, I'll gladly appoint the public defender to represent you this morning. You do have a right to have contact with folks on the outside, family, friends, counsel. If you have not had a chance to make that call, please let me know. We'll make sure that that happens. Finally, and most importantly, you're advised that you do have an absolute right to remain silent with regard to the facts which surround your arrest. I encourage you to do that. These proceedings are recorded. In addition, there is an assistant state attorney in the courtroom with me. If you say something that tends to incriminate you, they will use it against you in the prosecution down the road. I now need each and every one of you there at the jail to please raise your right hands and be sworn. Y'all solemnly swear or affirm, tell truth, whole truth, nothing but the truth. Outstanding. When I call your name, please step forward to the podium. Alexa Beam.
Judge, she entered a plea here yesterday, I believe, to 10 days.
Good morning, Your Honor.
Morning, Alexa. So that's why she's free on Pinellas.
Yes, sir.
Yes. All right. So, Alexa, what I have this morning for you now is a warrant out of Pinellas County. The judge in Pinellas apparently determined that you failed to appear on some charge and then set a bond of $1,031. $1,013. Sorry. So has she done her 10 days, or she's doing her 10 days?
I think she still had a few more to do,
okay.
But if they want to come get her, they can release her to them.
Right, yeah. All right.
And I do want to say that she had stipulated to the $100 restitution, and in fact it was $100 and we submitted the order.
Okay. So Alexa, the bond on the warrant, like I said, is $1,013. If Pinellas will come get you while you're still serving that sentence that you got yesterday, I certainly have no problem with you finishing your sentence in the Pinellas County Jail. If they won't come get you until you finish your sentence, when your sentence is finished, if you had the ability to post the bond of $1,013, you could do that. Then you'd go down to St. Pete and find out when they want you in court. If you can't post the bond and you finish your sentence, Pinellas would then have 5 days to come get you. If they failed to pick you up within 5 days, they'd bring you back to see me. We'd find out what the holdup is, okay?
Judge, at the most, she has one more day.
Okay.
At the most.
All right. Very good. Thank you, Alexa. Rebecca Fancher.
Your Honor.
Morning, miss. What's your date of birth?
6/2/68.
All right, Rebecca, this is a warrant also out of Pinellas County for a grand theft. The judge that issued this warrant sets your bond at no bond. Unfortunately, I can't change that. So we are going to let Pinellas County know that you're here and ready to go. They have 5 days to come get you. If you have not left the Hernando County Jail in 5 days, they're going to bring you back to see me, and I'll find out what the holdup is, okay? Thank you. Jennifer Kent.
Judge, I think she has a felony also, but I think this is something we can resolve at, say, no vehicle registration.
Oh, yeah, this is mine anyway.
She's got 2 days, yeah.
Yep. Do you have any objection to that?
I think she took drug PTI, so we really just wanted the time served.
Okay. So, Jennifer, you want to take time served on this and get out of jail?
Yes, I do.
Very good. You understand by entering a plea today, you give up the right to have a trial by jury, the right to confront the witnesses against you, the right to remain silent, the right to have a lawyer, but you're willing to give up those rights so we can take care of this today?
Yes.
In case
Go ahead. I actually had a failure to appear because I didn't remember about it because my memory is bad.
Yeah, no, Jennifer, I understand nobody's going to charge you with failing to appear. We're just going to resolve this registration charge and get you on your way, okay?
Do we know if she had the EPD originally?
I'm sorry, Jennifer, what did you say?
I said I get to go home today.
If there's nothing else keeping you there, yes.
Okay.
Okay. So in case number, hang on. In case number 17 CT 4189, as to the charge that you operated a motor vehicle that was not registered, how do you wish to plead? You can plead no contest.
No contest.
Very good. I'll accept the plea, find it's freely and voluntarily made. I'll withhold, I'll adjudicate you guilty, sentence you to 1 day, credit 1 day served. Be a fine and court cost of $438 and $50 for the day in jail. But that takes care of it, Jennifer. If there's nothing else keeping you in the jail, you will be released today, okay?
Thank you.
Thank you very much. Melissa Lambert. Morning, Miss Lambert. What's your date of birth?
5183.
Miss Lambert, you're here on a warrant that was signed by Judge Toner. He found probable cause for 1 count of grand theft. As to that charge, you want to represent yourself. You want to hire a private counsel. Would you like the
I need a public defender, please.
Very good. I'll appoint the PD. State.
Yes, sir. I'm showing an arrest 2016 for aggravated assault with deadly weapon, but it was dropped. And I'm not showing any out-of-state history.
Okay. Melissa, I've got an address for you on Ryan Street in Spring Hill. Is that where you live?
Yes, sir.
How long have you been there?
About 6-7 months.
You have a job these days?
I guess.
What do you do?
I'm a dancer at Lollipops.
Okay. I'm going to set your bond at $1,000. We're going to change your date. I'll have you back on the 29th of January. I think they told you February 6th. We're going to have you back on the 29th. And
Okay.
the bond's $1,000. When you get out, make sure you contact the public defender right away, okay?
Yes, sir. Thank you.
Zachary Beatty. Morning, sir. What's your date of birth?
6/23/64.
Good. Zachary, the charge this morning is trespass. There's probable cause for that charge. As to that charge, you want to represent yourself. You want to hire a private counsel. Would you like me to appoint the public defender?
Well, that'll be public defender.
All right. Appoint the PD. State.
Excuse me?
In looking it up, he's been in court the past November, October, August for either trespass or some type of alcohol offense. Backing up from that, Largo of this summer, no contest, disorderly intox in June of this year, of 2017, December 2016 in Temple Terrace, Tampa, resisting. I could keep going, but it's multiple
Yep.
similar type offenses.
Very
and
good.
then
That's good. Zachary, I'm going to leave the bond at the $500. I'm going to have you back in court on the 31st of January. If you don't bond out, the public defender is going to come to the jail and talk to you about your case, okay?
Yep.
Thank you. Donald McCray. Morning, sir. What's your date of birth?
10/13/61.
The charge this morning is battery being domestic in nature. There's probable cause for that charge. As to that charge, you wish to represent yourself. You can hire a private counsel. Would you like me to appoint the public defender?
Public defender, please.
I'll appoint the PD. State.
yes, sir. I'm seeing an out-of-state record, Ohio, for it looks like a possible DUI and possession of cocaine.
Nothing local.
No, sir.
And Donald, I had an address for you on Ceylon Drive in Spring Hill. Is that where you live?
Yes.
How long?
7245 Ceylon.
Okay. How long had you been there?
A year and a month.
And Miss Moore lives there as well?
Yes, and her aunt too.
Okay. Do you have a job these days?
Yes, if I still have one after today, yes.
Okay. What do you do?
Janitorial maintenance.
Okay. And Donald, I'm going to set your bond at $500. Condition of the bond, however, is that you have no contact with Miss Moore. No contact means no contact of any kind. You don't call, you don't write, you don't email, you don't text message. You don't contact her through any other social media. You don't have a third person contact her. You don't go where she lives. You don't go where she works. You don't have any contact of any kind. Any way that you might imagine contacting her, I forbid you to do that. If you have contact and we find out about it, your bond can be revoked and you can be held without bond until the charges are resolved. It means no contact even if she wants the contact. So if you answer your phone and hear her voice, you should hang up. If you're out and about and see her, you should turn around and run the other way. You need to understand that she cannot drop the charges against you. That is not a decision that she's allowed to make. She may go to the state attorney's office and ask them to drop the charges. She may tell them that she's not interested in pursuing this matter. But that decision belongs solely to the assistant state attorney handling your case. So unless that person or the judge on your case tells you the charges are dropped, you must assume they are not dropped and you must not have contact. In addition, I have to hold you today at the jail up until 4 p.m. so that if she wanted to serve you with a civil injunction for protection against domestic violence, we'd know where to find you. If you get the civil injunction, it's doubly important that you not have contact because in that case, not only would you get your bond revoked here, but you could get new charges for violating the injunction. As far as the address on Ceylon Drive is concerned, as long as she stays there, you'll have to stay somewhere else until we get this case resolved. You can go by one time to collect your clothes, your toothbrush, whatever you need for wherever you plan to stay. To do that, however, you must contact the sheriff's office first. They will then meet you there with a deputy who will stand by while you collect your things and get going where you're going. I will have you back in court on January 31st. Very important, sir, that you contact the public defender's office before that day, okay?
Yes, sir.
Thank you.
Is that a 10% on that 500 or?
I'm not a bondsman. I think they charge you $100 though.
All right, thank you,
All
sir.
right, thank you. Michael McVicker. Michael, what's your date of birth?
12/29/83.
Michael, have a total of 7 charges. I've got a grand theft, another grand theft, defrauding a pawnbroker, dealing in stolen property, a petty theft, and then another defrauding and another dealing. There's probable cause for all those charges. As for those charges, you want to represent yourself, you want to hire private counsel, or would you like the public defender?
I already have a public defender for another case.
So I assume you'd like them on these cases as well.
Yes, sir.
Very good. And so, Steve.
He's set for arraignment 129.
Okay.
Offense date for that was 12/29.
Okay, these predate that.
That's why I was just double
Yeah.
checking.
So 129 is where we're going to go with all of these.
Yes, sir.
And
Looks
then
like the judge is
other history.
Yes, sir.
If he has any.
I have just a moment.
Yep.
I told you about the one that's pending.
Right.
He went, it looks like a Florida Reception Center. He went on a dealing in stolen property, giving false information to a pawnbroker back from Martin County in 2013, dealing in stolen property in Hernando, probation violation 2013, trafficking controlled substance, 2011 Hernando conviction, 2008 obtaining controlled substance by fraud. I'm seeing some other probation violations and other possession.
Okay. And Michael, I have an address for you on Marengo Street in Brooksville. Is that where you live?
Yes, sir.
How long have you been there?
A year.
And did you have a job these days?
No, sir.
Okay. All right. On the first grand theft, I'll leave the bond for the schedule, which is the $2,000. I'm going to move that to the 29th of January where your other case already is. On the second grand theft and the defrauding, I'll set those at $2,000 as well. On the dealing at $5,000. So we're up to $11,000. Those are also coming back January 29th. And then on the final 3 charges on the petty theft, I'll set the bond at $500. The defrauding at $2,000 and the dealing at $5,000, so it's about $18,500 all the way around on these. All of these are coming back on the 29th of January. If you can't get out, of course, the public defender is going to come see you at the jail. All right?
Yes, sir.
Thank you. 500. Michael Nutt. Michael, what's your date of birth?
12/4/86.
Michael, you're here on a warrant out of Hillsborough County. Apparently a judge down there believes that you failed to appear on some criminal charges. So he's issued this failed to appear warrant and set the bond at no bond. I cannot change that. We'll let Hillsborough know you're here and ready to go. Give them 5 days to come get you, all right?
Your Honor, I was all warrant on that. The only reason I missed court is because I was incarcerated here doing my sentence.
Okay, and that, I will tell you, Michael, that being in somebody else's jail is probably the most common reason people fail to appear. But unfortunately, there's nothing I can do for you. You got to get to Hillsborough and tell the judge you didn't see what the story is, and they'll work it out from there.
All right.
Thank you. David Reese.
And Judge, we do have someone in the audience.
Good morning, sir.
Good morning. David, what's your date of birth?
8/16/82.
David, first thing I have is a driving under the influence. There's probable cause for that charge. And then, David, it appears that you're currently on felony probation. Is that right?
Yes, sir.
And where did you get sentenced? What county?
Hernando.
Okay. So there's a probable cause arrest for the violation of probation, and there's probable cause for that, of course, as well. As to those charges, you want to represent yourself, you want to hire private counsel. Would you like me to appoint the public defender?
Well, I have the money to hire private counsel, but I would have to bond myself up for that, and I don't think I have a bond on one of the charges.
Yeah, you're not getting out, David, because of the VOP. You're going to be on no bond. So you want the PD, or you want to have somebody on the outside try to help you get in counsel?
No, I'll take a PD for right now.
Okay. I'll appoint the public defender. Like I just said, the violation of probation case will be no bond. I'm going to change the date on that one. It's coming back on January 29th. The public defender will come see you. If you're able to figure out arrangements to get private counsel, make sure that you let the public defender know so they don't worry about you, all right?
All right.
And then on the DUI, we'll leave the bond at the $500. That's coming back on the 31st of January. I'll also appoint the public defender in that case, and someone from the PD's office will be out to see about both your cases before your court dates, okay?
That's fine.
Very good. Thank you, sir.
You're welcome.
Robert Sachs.
Sir.
Morning, Robert. What's your date of birth?
4/25/78.
Robert, you're hearing a warrant signed by Judge Toner. Apparently you failed to appear in front of him on a charge of battery, second or subsequent. As to that charge, you want to represent yourself. You're going to hire private counsel. Would you like the public defender?
I have a lawyer already.
Okay. Is he a public defender or a private lawyer?
It's a private lawyer.
Okay. Does he know where you are this morning?
I have no idea, sir.
Okay. The bond on Judge Toner's warrant is $40,000. I can't change that. I'm going to change your date to the 29th of January. So it's important that you get a hold of your lawyer as soon as you can. Let him know that you're in jail and what your court date is, okay?
Yes, sir.
Thank you.
All right.
Cleveland White.
Looked like the lawyer was canceled.
Morning, Your Honor.
Morning, Cleveland. What's your date of birth?
05/4/86.
All right, Cleveland, you're here on a warrant for a grand theft. The judge that signed the warrant found probable cause for the charge. As to that charge, you want to represent yourself. You want to hire private counsel. Would you like me to appoint the public defender?
Public defender.
Appoint the public defender. It looks like he's got an open case. Is that right? $15.15.
Set for 2/2 pre-trial.
Yeah. Okay, and I don't have the warrant this morning, so I don't know about timing, so.
Hang on one second.
Yeah.
I'll look at it. The case that is pending is 7/15/27. The theft. we have in our system as 12/26/17. So it's after.
So this one would have
The
been
new one is after the
after he.
other case charge, yes, sir.
Okay. And so the state have a request.
Yes, sir, we would ask that you RCO on 17 CF 1515.
Okay. All right. So Cleveland, what we'll do on this case, I've appointed the public defender and set the bond at $2,000, and I'm going to have it back on February 2nd, which is where your other case is, so that your cases will be together. And then with your other case, which is 17 CF 1515, job 1, when you're on pretrial releases, don't pick up new charges. It appears that you have. So pursuant to Florida Statute 903.0471, I'm going to revoke your pretrial release in 17 CF 1515. So you're going to be held without bond until you get back to court on the 2nd of February. At that time, Judge Toner can revisit your bond if that's something that he wishes to do. The public defender is going to come see you at the jail before your court date, okay?
Yes, sir.
Thank you. Joseph Wilkerson. Morning, Joe. What's your date of birth?
4/11/83.
Joe, I have two charges today. I've got a robbery by sudden snatching and a misdemeanor battery. There's probable cause for those charges. As to those charges, you want to represent yourself, you want to hire private counsel. Would you like me to appoint the public defender?
Public defender, please.
I'll appoint the PD. State, what can you tell me?
Yes, sir. The charge of domestic battery, arrest for domestic battery strangulation, March of 2016, it was dropped. Possession of a concealed weapon by convicted felon, I'm not showing a disposition or dwell outside of Fernando, February 2016. Carrying concealed weapon, 2015, Fernando dropped. Possession of cannabis and paraphernalia, 2015, Fernando, it doesn't show disposition. Carrying a concealed weapon, adjudicated, Fernando, 2015. Probation violation, Marion County, 2012. Fernando, 2012, violation of probation. Marion, 2010, probation violation. Showing up Border State Prison or some type of registration for Department of Corrections. Additional BOPs, a conviction of strong arm robbery in 2007 out of Ocala.
That's good. Joe, I have an address for you on Valley Spring Drive in Brooksville. Is that where you live?
Yes, sir.
How long have you been there?
Full life.
Okay. Do you have a job these days?
No, sir. Just doing yard work for family.
We'll leave the bonds per the arrest affidavit, which $2,000 on the robbery and $1,000 on the battery. That's a total of $3,000. Condition of those bonds is that you have no contact with Zachariah Zorn. Did you hear me explain no contact earlier?
Yes, sir.
Did you understand that?
Yes, sir.
Very good. I'll have you back in court on the 6th of February. If you get out, Joe, make sure you contact the public defender's office right away, okay?
Yes, sir.
Thank you. Esnieldo Zulinga.
Wait.
Morning, sir. What's your date of birth?
9/7/82.
First thing I have for you is a warrant that Judge Rupi signed. Apparently, you failed to appear in front of her on the charge of carrying a concealed weapon. As to that charge, you want to represent yourself. You want to hire private counsel. Would you like the public defender?
Public defender.
Like the PD, state, what can you tell me about this charge?
Yes, sir. Give me 1 second.
Looks like he has an open felony, too.
Yes, sir. I was
Brand
trying to
new
look
one.
at that. There's a open. It's set for 117 arraignment, and the charge is aggravated assault with a deadly weapon.
Yeah.
I don't know that it's been filed yet at this time.
Right. And that
And,
clearly postdates this. So.
Yes, sir.
Okay. Hang on. Hang on.
And then a conviction for stalking property, not structure. It looks like some type of trespassing in 2013. It originally came in as a burglary and a probation violation. Looks like it was possibly out of a DUI here, Fernando, 2005.
Okay. And, sir, I've got an address for you on Champion Drive in Brooksville. Is that where you live?
Yes, sir.
How long have you been there?
A year and a couple months.
All right. Do you have a job these days?
No, I have an interview today.
Okay. I'm going to set your bond on this case at $1,000, which is what's on Judge Ruby's warrant. I'll have you back in front of her on the 19th of January. They told you the 31st, but the right date is the 19th. If you get out on that, you should contact the public defender right away. The other issue I have for you, sir, is a writ of bodily attachment. I don't have a contempt order. The writ of bodily attachment means that a circuit judge and a child support hearing officer determine that you owe some child support. They set a cash purge of $570. You have $570, sir?
I do, but it's, my fiance has it.
Can she get it to the jail?
I have to contact her, and I wasn't able to get in a touch of her.
Okay. Why weren't you able to get a hold of her?
She wasn't answering the phone last night. The sheriff there said she would call her and talk to her, and she's I don't know. But also too, you said something about an aggravated assault.
I know what he's saying.
I think you got my dad in my case.
Hang on. We're not talking about that charge today. You have other charges.
Sorry.
Let's not worry about it.
I do want to correct it. What he's trying to tell you, I think, is there's a junior and a senior. I think that's senior.
Okay.
It was confusing in the system.
Okay.
So that is not his charge. He doesn't
Okay.
have an open felony, and that's what he's trying to tell you.
Okay.
The other thing is on her charge, on the Miss Judge Ruby's charge. It is a probation offer if he wants to consider that at the court sitting time.
Okay. So this is the only thing he has open. This misdemeanor
Right.
case.
So if he wants to take the probation offer, that's what we're recommending.
So, Esnieldo, did you want to take probation on the carrying a concealed weapon case? Or do you want to have a chance to talk to the lawyer first?
Well, how long? What's the probation?
What we were asking, Judge, was an adjudication, 12 months of probation, 50 hours community service, no possession of any weapons, costs.
Okay.
So it really is the probation
So,
with 50
so
hours.
what it would be, sir, if you took the probation, I'd adjudicate you guilty, put you on probation for 12 months to do 50 hours of community service, or buy it off at $10 an hour. While you're on probation, you would not possess any weapons of any kind, and you'd pay a fine and court cost of $503. When you completed the requirements of the probation could terminate early. If that's something you'd like to do this morning, I certainly can take your plea. If you'd rather have a chance to discuss it with the public defender first, you certainly can do that.
I'd like to have a chance to talk to the public defender.
All right, that's fine. And then, how long has it been since you worked?
It's been, I do little side jobs here and there, so I pretty much work for myself.
Okay. All right. What I'm going to do on the child support is find that you're in contempt for failing to pay child support. The sanction for that contempt is going to be 10 days in the county jail starting today, or until you get the $570 to the jail. So get the money to the jail, and then you can bond out on your misdemeanor charge and get out of jail. Okay.
Okay.
In either event, on the child support case, when you get out, you should go see the child support enforcement office. Whatever the problem is with your child support, you want to get it cleared up, because if you don't get it cleared up, this process eventually would start over again and you get arrested again, okay?
Yes, sir.
All right, thank you.
Thank you.
What's that? I don't care. If you guys don't care. Okay. Well, we'll do it later. All right. And then Jeffrey Tennyson.
How are you doing, Your Honor?
I'm doing good, Jeffrey. As you might have detected yesterday, I got a little annoyed when we were trying to work through your case, trying to figure out what the heck's going on.
Yes.
So I had
sir.
the people at probation work through it for me, and we're going to try to get things straightened out right now. So.
Thank you.
Yep. Let's see.
And he told me this. How many days?
Let's see.
It was like 70 something.
It was 80. Let me get to that page. 86. Give him what I calculated. even if you add.
Okay. And at the moment, so you've got right now is the one that shows as an open misdemeanor is what was the felony, right?
Yes, sir.
So 174591, that is remanded from circuit court.
It is now a petty theft, $100 or more, but less than $300.
Right. And then the misdemeanor that's reopened, 173159, is the BOP case that has caused all the problems. And that, as we sit here today, is all that Jeffrey has, right?
That's fine. Yes, sir.
Okay. And let's see. Okay. And on the misdemeanor, Candace, the new one,
Yes, sir.
when did he get arrested? If you
Mr.
have,
Bauer, can you help me on the arrest? I've got.
On the new one,
yeah.
Show the offense date of October 26th.
And I think it was a warrant. I think that it was, and I think he got arrested at the beginning of November or something like that.
November 16th.
Okay. And that was not part of the original VOP, and that's where things ran off the rails. And you've been in then continuously, Jeffrey, since the 16th of November?
Yes, Your Honor.
But the offense was 10/26.
10/26, right. Okay. And then Dave, with your calculation of his time, is that because he had some other time on the older case?
yes.
Because he was arrested on a no bond at some point in September, I think.
Yes, I believe that was an additional 28 days there.
Okay. So right now he's been in 57 days on what has become the 17 MM 4591. And Candace, what other history do you have other than these two thefts?
Yes, sir. The only thing I can pull up CSIS if you'll give me just a second.
Sure.
Sorry, I don't have a history here.
No, this is all, we're kind of on the fly with this, I understand that. This is CT case, looks like another felony from last year that's closed too, which was driving on a suspended license. But that got remanded to a CT case.
The only thing I was aware of that's open right now is two misdemeanors.
Right. Well, last year he got arrested on a felony Willis that they remanded down to misdemeanor. And that case got closed somewhere along the way.
Sorry. He's as old as I am. I was doing 96. Okay. So I'm seeing that petty theft, the grand theft that got remanded, the violation of zone probation, the second Dwellis CT in 2017, a felony arrest for, like you said, the Dwellis, that may have been a remand to that other charge, I'm not sure.
Right.
Then a 1991 misdemeanor, looks like it was a battery that must have been a violation of probation, a DUI, and it looks like that went into a BOP, and I've never seen this charge listed this way. Night prowling, 1988.
Okay. So Dave, once again, I'm sorry, the total time on 3159
Was
86.
86.
And on the new one, Candace, is there any restitution?
I'm not showing that there has been a, let me go to the felony. There's nothing listed under the misdemeanor number, but I want to check when it gets transferred. I'm not seeing any victim contact to tell me.
Okay.
facts involves selling something.
Okay. I'll tell you what, because I'm going to plead him out this morning, but I'll reserve on that case. So in case there's something out there, we can still catch it.
Yes, sir. It looks like they said there's supposedly it's around $100 range. I don't know if he'd be willing to stipulate to $100 cap.
Okay. All right. Yep. All right, Jeffrey. If you're interested, I'm willing to plead out today to your time served. It would mean admitting a violation of probation in the first case and pleading no contest in the second case. You'd get time served on both of them. There'd be fines and costs and various things on both of them. I would, on the second case, if you're willing to stipulate that restitution equals $100, I would order that. If you think there is no restitution, then I would order restitution but reserve for 60 days, and the state would have a chance to investigate that, and they would hit you for restitution sometime in the next 2 months, but you'd get out of jail today either way. Are you wanting to resolve your cases this morning?
I want to resolve them, sir.
Okay. And then in the newer case, do you want to stipulate that restitution is $100, or do you want
$100 or
less?
And if I find that it's less, I'll turn in less. But the maximum it could be would be $100.
Be $100. And
So
if the restitution is zero, then you'd get an order that says you don't owe anything.
Yes.
But the most it could be is $100.
Yes.
Okay, very good. So let's start with the old cases. Jeffrey, you understand by entering an admission to a violation of probation, you give up the right to have a trial to the court, the right to confront the witnesses against you, but you want to give up those rights so we can take care of that case today.
Yes.
Case number 17MM3159, do you admit that you violated your probation?
Yes.
I'll accept the admission, find it's freely and voluntarily made, revoke and terminate your probation unsuccessfully, adjudicate you guilty of the underlying charge. If that was not done before, sentence you to 86 days in the county jail, credit to 86 days served. There'll be a $50 cost of prosecution, $100 for the public defender's office, and your cost of incarceration. And then in 17MM459, as to the charge, now it's petty theft, right? Yep, of petty theft. How do you wish to plead? You can plead no contest.
No contest.
I'll accept that plea, find that it's freely and voluntarily made. I'll adjudicate you guilty. I'll sentence you to 57 days in the county jail, credit 57 served. There'll be a fine and court cost of $620, $100 for the public defender, and I'll order restitution in an amount not to exceed $100. That takes care of both cases, Jeffrey. If there's nothing else keeping you in the jail, you will be released today, all right?
Thank you very much.
All right.
Your Honor?
Yes, sir.
Do I have to report to probation, or am I off
You're all
probation?
done. No paper, no nothing, Jeffrey. You're all done.
Thank you very much, sir.
Thank you.
And that if we turn in that order, we would be doing a reduction to lien.
Right.